a very warm welcome to Thorough Newspaper Analysis. Today is 15th of April and this video series is brought to you by LawSikho. Now, as far as the agenda for today is concerned, at the very outset, we're going to have an understanding of some of the important national as well as the international news segment. This is going to be followed by legal news update segment where for today we have one update, and at the very end we have an editorial oriented discussion segment which is essentially aimed at developing the skill of critical thinking. For today, we have opted for or chosen two editorials, the title of first of which is Why Supreme Court Feels Paragraph Numbers in Judgments It Can Be Really Helpful. तो देखिए essentially हुआ क्या था कि सुप्रीम कोर्ट के पास एक अपील आई which challenged a decision of the Honorable High Court of Punjab and Haryana. एंड इसमें आर्ग्यूमेंट्स के दौरान बेंच को ये रियलाइज हुआ कि इस जजमेंट के जो पैराग्राफ्स है वो नंबर्ड नहीं है. So thereafter, the bench asked its registry to issue this directive to all courts and tribunals to make sure that paragraphs in a judgment, they are numbered. So we're going to have an understanding of certain aspects of this particular decision in certain detail. The second editorial, it is titled as A Reminder about Unfettered Constitutional Posts. यहाँ पे essentially इस article का जो point of discussion है, that is the importance of having independent constitutional bodies or authorities. इसमें हम डिटेल में चर्चा करेंगे कि what is the mode of appointment of the position holders of such authorities, and इसमें हम जो जितनी भी constitutional authorities है उनको दो segments में divide करेंगे. पहले तो वो सारी authorities जहाँ पे कि president के पास power है to make the appointment but on the aid and advice of the Council of Ministers, which is of course headed by the Honorable Prime Minister of India. And secondly, वो सारी posts जहाँ पे कि it has been mentioned in the Constitution that the President shall appoint under his warrant and the seal of his office. So we're going to have an understanding कि इन दोनों में difference क्या है and especially इसका interplay क्या होगा on the independence of these institutions, and this is in light of two recent developments. एक पे तो हमने हमारी प्रीवियस डीएनए में बहुत ही डिटेल में डिस्कशन करी है which is with respect to the remarks passed by the Honorable Chief Justice of India about how governors should not indulge themselves into political fiascos, and this is in light of the entire Maharashtra political turmoil, and secondly the change in the appointment mechanism of election commissioners and the Chief Election Commissioner of India by involving the judiciary as well. So with this, let's dive into the TNF for today. The first update in the national news segment, this is with respect to India's ranking improvement in the global business environment ranking. So see, recently India has improved its ranking by 6 positions in the latest business environment ranking globally. The data for the same were released by the Economist Intelligence Unit. And as far as the factors contributing this improvement is concerned, it would have to be the technological readiness of our country, coupled with political environment which is conducive, and thirdly, the foreign investment among other factors. The three countries who are going to lead the charts in the next 5 years in this particular ranking, these are Singapore, Canada and Denmark. Next, we have an update with respect to the Solar Energy Corporation of India being given the status of a Miniratna Category 1 entity. So the Ministry of New and Renewable Energy, it has granted the Miniratna Category 1 Central Public Sector Enterprise status to the state-owned Solar Energy Corporation of India Limited, which was established in the year 2011. This update is with respect to Yes Bank creating history by being the first Indian company with over 50 lakh shareholders. The other two companies at the second and third places are, second we have Tata company, which is Tata Power. It is, as far as Tata is concerned, it is with 38.5 lakh shareholders at second position, and this is followed by Reliance Industries with 33.6 lakh shareholders. Next, we have an update in the sports segment. This is with respect to ICE Women's Asia and Oceania Championship. So the India Women's Ice Hockey team, it is all set to compete in this year's IIHF Ice Hockey Women's Asia and Oceania Championships, which is scheduled to be held from 30th of April to 7th of May this year. Next, moving on, this is with respect to the preparedness initiation, the Animal Pandemic Preparedness Initiative being launched. This initiative, it aims to enhance India's preparedness and response to animal pandemics with a focus on zoonotic diseases that pose a threat to both animals and human health. This initiative, it is going to help in improvement in the vet services in our country and the infrastructure thereof, along with improvement in disease surveillance capabilities, early detection and response, building the capacity of animal health professionals, and of course, awareness among farmers through community outreach programs. Now, this is an update with respect to the National Forensic Science University becoming the first government university of India to open a campus abroad. So this happened while the visit of our External Affairs Minister, Shri S. Shankar, to Uganda, and the campus is being opened in Jinja in Uganda. And the concerned minister, he stated that this is a significant milestone in the bilateral ties of both the countries. As far as this institution is concerned, it is already an institution of national importance, and it's the world's first university which is exclusively dedicated to forensic sciences. Now, before we proceed with the next update, I have a question which is with respect to the Uganda visit of our External Affairs Minister. So recently, we've also discovered and covered the same in our TNAs. The minister concerned, he has signed an agreement with the country of Uganda for the development or enhancing the aesthetic appeal of one of India's cities, which is in fact one of the earliest civilizations the world has seen, and one of the earliest settlements, sorry. So I would like all of you to put down your answer in the comment section. Now moving on, the Prime Minister of India, he has inaugurated AIIMS Guwahati, which is the first in the northeastern region. So with 50-bed tertiary care capacity, teaching hospitals with 24 undergraduate departments in 3 medical colleges, this is going to start with 100 annual MBBS student intake, taking total MBBS student intake to 1,500 in the state of Assam. The super speciality hospital, this is going to provide healthcare not only to the people in the state of Assam, but also to others from the northeastern region. Now, this has brought us to the international segment for today. The first update is with respect to India signing an MOU with World Food Programme for the purpose of sending wheat to Afghanistan. See, India has signed this MOU with the WFP, paving the way for sending 10,000 metric tons of wheat to the people of Afghanistan. This is in pursuance of India's declaration, which was made last month. This was made at the India Central Asia Joint Working Group on Afghanistan, where India committed that it is going to send 20,000 metric tons of wheat to through Iranian port to the country of Afghanistan. I'm sorry. Now, the second update in the international segment is with respect to a missile test being conducted by North Korea. So, North Korea has announced that it had tested a new solid fuel intercontinental ballistic missile called Hwasong-18, and this is done as per the leader of the country for enhancing the preparedness of the country to counteract any nuclear attack. And this has brought us to the legal segment for today. The first update and last update, first and only update that we have, it is coming from the Honorable Apex Court. This is with respect to the Registration Act. So the Supreme Court has held that unregistered agreement to sell, it is admissible, as well as it is a form of evidence in civil suit for specific performance. So the Supreme Court has held that Section 17(1)(a) of the Registration Act, this is the only exception to the proviso of Section 49 of the same Act, that the proviso to Section 49, it shall apply to documents other than the ones that were referred to under Section 17, subsection 1A. The name of this particular case is R. Hemlata versus Kasturi. And this has brought us to the last segment for today, where we have 2 important editorials to discuss, and we're going to start off this segment with the Supreme Court's directive holding that all the courts and the tribunals, they are required to number the paragraphs in their judgments. So देखिए पहले तो हम of course we're going to have an understanding of the why of this particular article, and this is going to be followed by a very brief understanding of what the Supreme Court had observed with respect to the matter of adopting uniform judgment format and numbering paragraphs of a judgment. And at the very end, we are going to have an understanding as to why it is desirable for courts to have numbered paragraphs and a uniform format of writing judgment. So let's start off the discussion with the why of this article. So see, देखिए Thursday को क्या हुआ था? Supreme Court it had observed that all courts and tribunals, as a matter of practice, it must adopt a uniform format in writing judgments and orders. And the bench also added that it would be desirable to number all paragraphs in order. अगर हम इस केस के फैक्चुअल मैट्रिक्स को ब्रीफली देखें तो हुआ क्या था एसेंशियली द बेंच डिवीजन बेंच ऑफ द ऑनरेबल एपेक्स कोर्ट इट मेड द सजेशन इन अ सर्विस लॉ मैटर जजमेंट जहाँ पे कोर्ट जो है इट वाज डीलिंग विद एन अपील which had essentially impugned a decision of the Honorable High Court of Punjab and Haryana involving a commandant of the BSF. तो हरियाणा पंजाब एंड हरियाणा हाई कोर्ट की जो जजमेंट थी इट वाज नॉट नंबर्ड पैराग्राफ वाइज सो देयरफॉर द सुप्रीम कोर्ट स्टेटेड इन हाई कोर्ट it is desirable that all courts and tribunals, as a matter of practice, number paragraphs in all orders and judgments, factoring in the judgments A4 extracted. So the bench directed the Secretary General of the Supreme Court कि वो circulate कर दे इस particular judgment को to the Registrar General of all the high courts in the country, and इसका purpose ये है so that they can consider adopting a uniform format for judgments and orders that includes paragraphing as well. It said that the Chief Justices may direct courts and tribunals subordinate to the high courts to do the same. Now let's understand why does it matter. तो देखिए essentially होता क्या है, जो सुप्रीम कोर्ट का रिकॉर्ड ऑफ अ पर्टिकुलर केस होता है ना, उसको हम कहते हैं पेपर बुक. एंड यूजली ये फाइंड किया गया है कि जो पेपर बुक होता है किसी केस का ये बहुत वॉल्यूमिनस होता है. और वो क्यों होता है? बिकॉज इट कंटेन्स द entire case document. So it would contain your the arguments advanced by the parties and the judgment, the citations and the factor matrix and all of these factors. So therefore it gives out a very voluminous context. So इसीलिए also given the fact that Supreme Court already has a lot of workload and therefore it gets really less number of time to devote to per judgment. Only it gets a few hours to locate the meat of the judgment which is under challenge. So therefore it is desirable to have the paragraphs numbered so that a quick reference to the same can be made. So it is what the article says, that given the huge number of cases the Supreme Court hears every day, judges often have only a few hours to locate the meat of a judgment that is under the challenge or that is under a challenge. So numbered paragraph in lengthy judgment, it saves the time of the court. And while dictating judgments in open court, judges, they refer to paragraph numbered in precedents that needs to be produced verbatim in the judgment. And also, एक 2021 का अपडेट है जिसमें भी सुप्रीम कोर्ट की यही ऑब्जर्वेशन थी, जहाँ पे कोर्ट ने ये बोला था that using all judgments to carry paragraph numbers as it allows for ease of reference and enhances the structure, improving the reliability and accessibility of the judgments. Additionally, बेंच ने ये भी बोला था कि अगर जजमेंट की स्टार्टिंग में ही एक टेबल ऑफ कंटेंट हो जाए तो that would also make it more viable and usable for the general public also to refer to the relevant pages. So with this, let's advance to the next editorial that we have for today. That is with respect to enhancing or maintaining the need for maintaining independence of constitutional authorities in the country. So देखिए essentially पहले तो of course we're going to have an understanding of the issue involved in this particular article, and उसके बाद में हम ये देखेंगे कि एक independent constitutional body authority की democratic system में कितनी ज़्यादा वैल्यू होती है, and then हम हमारी constitutional provisions को sort of consider करेंगे, and we're going to have a parole of the same in order to understand कि हमारी constitution में जो independence की importance है उसको कहाँ तक हमारी कॉन्स्टिट्यूएंट असेंबली की जो डिबेट्स में हाईलाइट करा गया था उसको कहाँ तक हम वी आर एबल टू मेक इट इनटू और ब्रिंग इट इनटू इम्प्लीमेंटेशन. एंड इसी जब हम डिस्कशन करेंगे कॉन्स्टिट्यूशन प्रोविजंस के तो हम इसको दो कैटेगरीज में डिवाइड करेंगे. एक तो वो सारी कॉन्स्टिट्यूशन पोस्ट जिन पे अपॉइंटमेंट जो हो रही है दिस इज बाय द office of the president and the president is acting upon the aid and advice of the council of minister. And secondly जहाँ पे कि वो सारी institution जिनकी independence को ensure करना और भी ज़्यादा ज़रूरी हो जाता है because of the kind of role they play. And वहाँ पर it is stated in the constitution itself that president shall appoint, but the appointment is under the warrant and seal of the office of the president. And then this is with a specific reference to the office of CAG, which is Controller and Auditor General of India. And this is especially important because the author itself of the article, he was a former Deputy Controller and Auditor General of India. So he has put down his suggestions as to where are the reforms needed for the appointment to such a post. So with this, let's start with the editorial. तो देखिए, लेट्स अंडरस्टैंड द व्हाई एज टू व्हाट इज द इशू इन्वॉल्व. तो दो डेवलपमेंट्स इसमें हाईलाइट करी गई है. पहली वो डेवलपमेंट जहाँ पे क्या हुआ था कि जैसे आपने हमारे प्रीवियस टीएनएस में भी रेफर करा है, महाराष्ट्र पॉलिटिकल टर्मोइल, इट रीच्ड द डोर्स ऑफ द ऑनरेबल एपेक्स कोर्ट. बिकॉज महाराष्ट्र में क्या हुआ था कि जो शिवसेना लीडिंग पार्टी थी, जिसकी गवर्नमेंट थी, उसी के कुछ एमएलएस ने डिफेक्ट कर दिया. एंड द शिवसेना, a branch, a group of certain MLAs from the party, it clubbed with the BJP and it formed the government later. So both the sides of the parties, they approached the Honorable Supreme Court, and वहाँ पे सुप्रीम कोर्ट के सामने गवर्नर का जो इम्पोर्टेंट रोल होता है ना, उसके बारे में डिस्कशन आई. एंड गवर्नमेंट, सुप्रीम कोर्ट ने ओरली कुछ रिमार्क्स करे, वो ये थे कि इट इज़ इम्पॉर्टेंट that the court expressed its serious concern over the active role being played by the governors in state politics, which has the implication of sometimes toppling down a democratically appointed government. So you would see the gravity of the issue, because क्या हो रहा है कि जो we the people of India, we elect our representatives, and जनता के mandate को खारिज करते हुए काफ़ी बारी गवर्नर्स की पॉलिटिकल फियास्कोस में इन्वॉल्वमेंट के कारण एक डेमोक्रेटिकली इलेक्टेड गवर्नमेंट भी टॉपल डाउन हो जाती है. So this is one development, and secondly is the important step that was taken in ensuring the independence of the Election Commission of India. वहाँ पे सुप्रीम कोर्ट ने क्या किया था, it divested the executive of its sole discretion in appointing the election commissioners and the chief election commissioner of India by forming a committee to suggest suitable names to man these positions. So essentially अब क्या है कि जो executive के पास sole अपॉइंटमेंट के राइट्स थे, दिस इज नाउ शेयर्ड बाय जुडिशरी एज वेल, बिकॉज कमेटी में कुछ जुडिशियल मेंबर्स भी होंगे. सो नाउ लेट्स अंडरस्टैंड कि क्यों ज़रूरत होती है इंडिपेंडेंस की ऐसे इंस्टीट्यूशंस की. तो देखिए, हमारी जो कॉन्स्टिट्यूशन है उसमें कुछ कॉन्स्टिट्यूशनल अथॉरिटीज़ का प्रोविजन है. एंड टू नेम अ फ्यू, इट वुड बी योर पब्लिक सर्विस कमीशन, Controller and Auditor General of India, which is CAG, the Election Commission of India, the Finance Commission, and the National Commissions for Scheduled Castes, Scheduled Tribes, and the Backward Classes, to name a few. Now, Constituent Assembly of India, they recognize the need for such independent institutions to regulate sectors of national importance without any executive interference unnecessarily. And therefore, it is an essential attribute of independence that it is these ये जो सारी institutions है, they do not bow down to the pressure that is being given by the executive, and they function they have a certain sort of autonomy in their functioning, because इनका जो purpose है वो बहुत ही important है for the national interest. So therefore, what has happened is, while empowering the President of India to appoint all constitutional authorities, जो हमारी constitution makers है in the Constituent Assembly of our the constitution framing body, it had kept in mind those institutions whose independence is of paramount importance to the country, and the manner in which the independence of these authorities, they could be safeguarded from the whims and fancies of the executives. तो अगर हम कॉन्स्टिट्यूशन के कुछ सर्टेन प्रोविजंस को रेफर करेंगे अब, तो हमें एक अंडरस्टैंडिंग ज़्यादा बेहतर होगी कि व्हाट दी कॉन्स्टिट्यूएंट असेंबली एसेंशियली एन्विजन्ड, एंड कौन सी इंस्टीट्यूशंस इन कॉन्स्टिट्यूशनल अथॉरिटीज़ में भी कौन सी अथॉरिटी ज़्यादा इंपॉर्टेंट है, उनका रोल इंपॉर्टेंट है, देयरफॉर उन पे एग्जेक्टिव का प्रेशर कम होना बनता है. सो लेट्स अंडरस्टैंड द constitution makers, they have used simple words such as shall be appointed by the president for the following authorities. पहला तो प्राइम मिनिस्टर. सो वहाँ पे आर्टिकल 75, if you open your direct and you read it, you would find a mention that the prime minister shall be appointed by the president. So it is just saying that shall be appointed by the president. This is followed by the Attorney General of India, which is Article 76, the Chairman and other members of the Finance Commission, Article 280, the Chairman and other members of the Public Service Commission, Article 316, and a Special Officer for Linguistic Minorities, Article 350B. This is followed by Article 324, which provides that the President will appoint the Chief Election Commissioner and the Election Commissioners subject to any law which is made in that behalf by the Parliament. अब हम आते हैं सेकेंड ब्रांच ऑफ कॉन्स्टिट्यूशनल अथॉरिटीज, जिनकी अपॉइंटमेंट के लिए एक अलग से प्रोसीजर प्रिस्क्राइब है, एक अलग कुछ प्रोविजंस बनाए गए। सो सी, इफ वी हैव अ लुक एट द फॉलोइंग, जो अभी हम लिस्ट आउट करेंगे, यहाँ पर वर्ड्स जो यूज हुए हैं वो है शैल बी अपॉइंटेड बाय द प्रेसिडेंट बाय वारंट अंडर हिज हैंड एंड सील. So this is used while authorizing the president for appointment of judges of the Supreme Court and that of the High Court. जो relevant articles है वो है 124 and 120, 124 and 217. CAG, which is Article 148, for the appointment of governors, which is Article 155. Similar words have also been used in Article 388, 388A, 388B, authorizing the president for appointment of chairman and members of the national commissions for SC, ST and backward classes. पर अगर हम ओरिजिनल आर्टिकल देखें, जो ओरिजिनल आर्टिकल था which is parallel to or adjacent to Article 338, it had stated that there shall be a special officer for the scheduled castes and scheduled tribes to be appointed by the president. Now let's understand unrestricted unfettered choice. यहाँ पर कॉन्स्टिट्यूएंट असेंबली में कुछ अमेंडमेंट्स इंट्रोड्यूस करी गई थी विद रिस्पेक्ट टू द अपॉइंटमेंट प्रोसीजर ऑफ सर्टेन कॉन्स्टिट्यूशनल पोस्ट. एंड नॉर्मल जो कि प्रेसिडेंट शैल अपॉइंट, इससे we went to the second half, the second category, जहाँ पे ये है कि appointment is by the president under warrant and seal in his seal under his hand. तो let's understand कि वो क्यों हुआ और इसके पीछे constituent assembly का rationale क्या था. So see, in the draft constitution, the article for appointment of CAG 124, it had provided, and I quote, that there shall be an auditor general who shall be appointed by the president. So this is falling under the first category. जबकि अभी जो current है that is falling under the second category. So while moving an amendment to this article, it was stated in the Constituent Assembly that in clause 1 of Article 124, after the word president, the words by warrant under his hand and seal be inserted. The Constituent Assembly had discussed that the AG, like the Chief Justice of the Supreme Court, is to be appointed by the president, and therefore it is essential that the words by warrant under his hand and seal shall be introduced. The Constituent Assembly further discussed that the Auditor General shall be always independent of the of either the legislature or the executive, and he is the watchdog of our finances. So therefore his position must be made so strong that he cannot be influenced by anyone, whosoever may be in the position of power. So from this point of view, the author has expressed his happiness that the amendments have been moved, where the position of Auditor General, it has been made very strong. And on the same day, while initiating amendment for the article providing for the governor, जो कि draft 131 article था draft constitution का, it was moved to substitute the following, that the governor of a state shall be appointed by the president by warrant under his hand and seal. And Constituent Assembly में ये discussion हुई with respect to this amendment, that to say that the president may nominate a panel of names really means restricting the choice of the president. It gives power into the hands of the legislature, and it is necessary that the president should be free from the influence of the legislature. So therefore, this particular amendment was proposed and later passed. So essentially, हम इससे क्या conclusion draw कर सकते हैं, वो ये है कि for appointments to be made by the president under Article 75, 76, 280, 360, 324, the Constitution provides for certain conditions to be fulfilled by those who may be considered for such appointments. And in these articles, the word uses to be appointed by the president, and as such the president must act on the advice and the aid of the Council of Ministers headed by the Prime Minister. जबकि जो second category है वहाँ पे there is a greater level of independence that is available to the constituent, these constitution bodies. Now it is pertinent to note or keep in mind that the Constitution affixes the phrase by warrant under his hand and seal only to refer to appointments to the positions of judges, Supreme Court, both Supreme Court and High Court, and to the CAG and governors. So where it assigns a special status to distinguish from other constitutional positions, and this distinction is with respect to the important role that these institutions play. Now let's understand the special focus that the author has brought to the appointment mechanism of CAG. तो इसके रिस्पेक्ट में ये कहा गया है कि कॉन्स्टिट्यूशनल अथॉरिटीज सच एज जजेस ऑफ द सुप्रीम कोर्ट एंड द हाई कोर्ट एंड द कैग ऑफ इंडिया, they are to be kept free from political and executive pressure, whereas appointments of judges and election commissions, they have been free from influence of the executive. The need to set up a well-defined criteria and procedure for the appointment of CAG of India, it remains keeping in view the intention of the framers of the institution of the constitution, जो कि हमने evidently देखा ही constituent assembly की debates है. And the process of selecting a person to be appointed as the CAG of India, it should begin by appointing a committee constituting or consisting of the Speaker of the Lok Sabha, the Chief Justice of India, and the Chairman of the Public Accounts Committee to shortlist names of to be considered for appointment as the CAG of India, and a panel of 3 names. It should be forwarded to the President for him to make the final selection as in Article 148 of the Constitution of India. So this was the suggestion of the author. And with this, we have come to an end for the TNA for today. If you want to have an access to the study material, which is available for free of cost and provided by LawSikho, and in case you want to get access to the TNA slides, kindly feel free to join our Telegram channel. For the same, you may look into the link which is provided in the description, या फिर ये आप barcode भी scan कर सकते हैं. These are the point of contacts in case you want to get in touch with LawSikho. Also, the TNA quiz of yesterday's video, it is made available in today's video's description. Kindly go ahead and attempt the same. Thank you for being with us.